Hello, everybody.
All right, so Ms. Turner, I'm going to continue your bond in both cases. I'm going to continue your cases at your request because it's your witness issue. Both cases will go to pre-trial May 19th and jury trial May 21st and 22nd.
Going on still? I was supposed to be in fucking court.
Excuse me, that's not acceptable. You just committed contempt by using that kind of language in court and in reference to court. Is that you, Mr. King? I'll come back to you in a minute. I'm in the middle.
That's correct, Your Honor.
Okay.
That's who made the statement.
All right. Well, I'm going to wrap up Ms. Turner's case. Each of those hearings will begin at 9 a.m., but your attorney will tell you when he wants you here. The pre-trial on the 19th will be by Zoom. The jury trials will be live at the courthouse. Any questions about that, Ms. Turner? If you have questions, I direct you back to Mr. Paul. Anything else, counsel? Mr. Paul, you'll journalize this continuance?
If I need to, Judge, I will.
Well, you or Mr. Dean.
I've got the handy dandy fast forms back here where I can fill them out in about 2 minutes. So
okay.
Thank you, Mr. Dean.
All right.
That's not a problem.
Judge, we're ready to take up Skylar King.
Okay. We are on the record in let me qualify that. We are on the record in BU 2024 CR 263, State of Kansas versus Skylar Todd Helsel King. Please announce appearances.
Over here on behalf of the state.
Your Honor, Darren Patterson appearing on behalf of Skylar King. Mr. King does appear via Zoom audio visual. Judge, before I get into the case, I know that at the beginning of this docket, Mr. King came on. I don't think he realized he was actually in the court yet. I know I've talked to him. He's very apologetic about it. He does want to sincerely apologize to the court for that outburst. It's not something he would have done if he was in the courtroom, of course. These Zoom things, sometimes people don't understand what's going on. So he does apologize to the court. I think he wants to do that himself also.
Mr. King, did you want to address the court?
Yes, ma'am. I do very much apologize. I would never speak like that in the courtroom or really in front of a lot of people. So,
well, thank you. And I understand. I understand that you were frustrated and you're trying to make things work and be in court. So all is well at this point. All is forgiven. No contempt findings at this time.
thank you.
You're welcome. I know. I just really believe you didn't mean it for it to come out the way it did. Mr. Regier, Mr. Patterson, are we ready to proceed?
Yes, Judge. I would announce at this time that we, as the court knows, we were working on plea negotiations. Yesterday, we had one hiccup. That hiccup has now been resolved. So the announcement would be at this time, Your Honor, that Mr. King will be pleading guilty to the one count of criminal damage property. The part that was still causing trouble is that it has a DV tag. It's now been agreed that the DV tag will be removed so that it does not have a DV tag either. That upon the court accepting the plea of no contest to one count of criminal damage to property, there are agreed recommendations also that include some of the same things a bit might have done, and that's kind of where the hang up was at. He's already doing things, and rather than pile a whole bunch on him, it was agreed that he would continue to do what he's doing and provide all of the releases to his probation officer. So those will be the recommendations to the court at time of sentencing, along with other sentencing recommendations.
Mr. Regier, is that your agreement?
That is the state's understanding, Your Honor, in exchange for a criminal damage to property. Plea to that without a domestic violence tag, the state would move upon successful entry of such a plea to dismiss counts 1 and 2.
And are there any agreed upon dispositions for sentencing?
It is the state's understanding, Your Honor, as a preliminary matter. I based on my notes, it would appear that at the yesterday's hearing on February 3rd, it would appear that the victims did appear. However, I do not know if there was any notification as to today's hearing, but I'm not sure what the court wants to do with that, as the state does recognize this docket was somewhat set, somewhat on the fly, if the court will pardon me for saying so.
Well, let's see. I remember the victims. I remember 2 individuals appearing on the screen saying they were and this was not on the record. I was inquiring who they were. They said they were the mother and father, and someone had shared the Zoom code, so they were actually here in person by Zoom. I don't recall if we gave this date to them before they left. They left after the defendant did, but I think my instructions to the defendant was to call his attorney at 3:30, so I don't think they would have been a party to this date. Do we need to set over sentencing for that reason?
Your Honor, under these circumstances, the state would defer to the court's not wish to proceed. What I can tell the court is that it is the state's understanding that agreed recommendations for sentencing have been reached, and I believe that is the substance of the of prior plea negotiations in this matter.
What are the terms of the plea agreement besides dismissing 1 and 3 in exchange for count 2, no contest?
One moment, Your Honor. Your Honor, upon successful entry of the plea, the state would be recommending there be no fine, that the court impose court costs, the court determine attorney's fees, as well as impose, notwithstanding the amendment, a domestic violence fund fee, an underlying sentence of 6 months with 12 months of reporting probation, subject to all standard conditions, including a $6 probation fee, that the defendant shall be ordered to complete mental health assessments and follow recommendations.
I will, unless there's objection, Mr. Patterson, is that first of all your understanding of the rest of the agreement?
Yes, Judge, and I guess I would inquire of the state. It's my understanding my client's mother and stepfather were all for this plea bargain. In fact, I think they want it dismissed altogether. So that if Mr. Regier can confirm that they were in agreement with the plea bargain, I think we can still proceed pretty easily.
Mr. Regier, do you know if that's correct?
Your Honor, based off of my notes, there does appear to have been some recent communications between the alleged victims in this case and my office. However, I do not have any information as to the victim's position regarding the matters referred to by counsel for the defense.
Mr. King, do you know where your parents are right now?
Yes, ma'am. They're in Benton. My mom, I live with her a lot of the time because it's closer to my job. And since you gave me the release to talk to them and be with them the last time, I actually just started living back in Latham, but it's easier to live in Benton and work in Wichita at my shop. And I fix stuff for them. I love them.
Well, my question, sir, is do they know about this hearing today?
No. Sorry.
Do you? Well, I'm gonna go out on a limb because I think Mr. Patterson, I kind of sense the same thing he's saying, that I can't remember if they told me that off the record that was the county attorney or the clerk. Somebody had said that they should come on screen and address the court, and I shut that down. But at this time, I'm going to proceed with sentencing. Well, but I need to know if there's any restitution, Mr. Regier, for criminal damage. Can you try to get them on the phone, Mr. Regier or Mr. Patterson, since the no contact has been lifted? Could we get them on here real fast?
Your Honor, the state would request leave to go off mic and off camera at this time.
All right. Yeah, as you said, someone said a while ago, maybe it's Mr. Jensen. I don't want to have to redo anything. If I can,
And if, Judge, if I could be put in a breakout room with Mr. King, I will work it on the other side to see if we can't get them on here.
that'd be wonderful. Thank you. Missy, would you please put Mr. King and Mr. Patterson back in a breakout room?
Okay, Judge, she has the Zoom link and should be getting on here pretty quickly.
Very good. Okay, we are back on the record in BU 2024 CR 263, State of Kansas versus Skylar Todd Helsel King with Jared Regier for the state. The defendant in person by Zoom and with his attorney, Mr. Patterson. We are now joined by Penny Ross, the alleged victim of domestic battery in count 1. Ms. Ross, do you have Stephen Ross with you today?
And Judge, it looks like her audio is trying to connect and it's not connecting. There.
Can you hear me, Ms. Ross? Ms. Ross, if you can hear me, please raise your right hand or raise any hand. I don't care. It's not a no. She can't hear me either.
Okay.
Oh, you
Okay.
can. Very good.
I just got it. I'm just trying to figure this computer out. Just
Okay.
give me a minute here.
Ms. Ross, I've asked your presence today. Is your husband with you as well?
Yeah, let me go get him.
If you
I'll
would,
be right back.
please.
Okay.
Thank you. We are now joined by Penny Ross, alleged victim in count 1, as well as Stephen Ross, alleged victim in count 3. I've asked you both to be here today because of your rights as victims. There is a plea agreement before the court whereby both counts 1 and 3, the domestic battery would be dismissed and the domestic violence tag, if any, on count 2. I'm saying that wrong. Apparently the domestic batteries are 1 and 2 and count 3 is the criminal damage. Is that right, counsel, or did you file an amended?
No, that count 3 is a criminal damage property.
That's what I'm showing on the information, Your Honor.
Okay, so Ms. Roth on count 1 and Mr. Roth on count 2. The proposal is that those counts each be dismissed and count 3, the criminal damage to property, a glass front door belonging to each of you. The defendant would plead no contest to that, but the domestic violence tag on count 3 would be dismissed as part of the plea agreement. The sentencing proposal, and counsel, help me make sure I get this right, no fine, a 6-month suspended sentence, 6 months reporting probation. It looks like.
Forgive me, Your Honor, for interjecting. The state's understanding agreement is that a year of reporting probation is what is
1 year, okay. Why don't you go ahead and state the agreement so that the Roths hear it?
Your Honor, the state's understanding is that at the time of disposition pursuant to plea negotiations, the state would be recommending no fine, that the court impose court costs as well as determine attorney fees, $100 domestic violence fund fee, an underlying sentence of 6 months with 12 months of reporting probation, subject to all standard conditions, $60 probation fee, that the defendant be ordered to complete a mental health assessment and follow all recommendations.
Now, as victims, I just wanted you to know that was the plea agreement. Do you want to talk to the county attorney about any of that before I proceed?
Well, I was just wondering on the mental health thing. I know, you know, with Skylar's TBI and stuff like that, you know, nothing's changed on that. When they did the brain scan and everything from back when it all happened, nothing has changed on.
Well, I think that the agreement was, correct me if I'm wrong, counsel, but I think their agreement was that he had continued to address his mental health either by a new assessment or continue what he's doing, which, Mr. Regier, you did say a mental health assessment, you want a new assessment. I thought I heard Mr. Patterson say he was going to continue with the treatment he was in. Maybe I,
He is currently in treatment, Judge, and doing well from what I can tell. So that it's something that he can sign a release to the probation officer and they can review that.
okay. Well, if there's no objection, I will proceed. So, Mr. Helsel King, at this time, how do you plead to the sole remaining count, the amended criminal damage to property, no DV tag?
No contest.
No contest. By no contest, you don't want to admit the charge, but you don't want to deny it and take it to trial?
Correct.
All right. And is anyone making you give up your right to a trial? Because we do have a jury trial setting.
No.
All right. And you understand that even though you're pleading no contest, that is, you're not admitting the charges, you'll still most likely be found guilty without the benefit of trial, and you will not be able to appeal your conviction.
Yes.
All right. Then, Mr. Regier, what factual basis would you proffer?
Yes, Your Honor. Were this case to proceed to trial, the state's evidence would show, pursuant to the affidavit beginning with paragraph 4, that
And this is the affidavit to support the arrest warrant, right?
Yes, Your Honor.
Okay, go ahead, please.
Your Honor, the affidavit, paragraph 4, appears to refer to an encounter occurring on Friday, June 7th of 2024, at which time law enforcement was dispatched to a certain address in Benton, Butler County, Kansas, thereby giving this court with jurisdiction concerning a certain disturbance. Later on in paragraph 7 through 8 of the affidavit refers to an incident where the defendant allegedly punched a front glass door, breaking it, as well as subsequently admitting to the same to law enforcement.
I find the defendant has knowingly and voluntarily entered his no contest plea, and the state has provided a factual basis. I will proceed to sentencing at this time. I have heard both counsel's recommendations. Do the victims have any recommendations at this time or any restitution to request for the damage to the window?
Yeah, no, Your Honor. Skylar does a lot of work around my house, around our house, and he does a lot of stuff for us. No.
Okay, thank you. At this time, Mr. Helsel King, you are not fined, but you are sentenced to 6 months in the county jail. That will be suspended so long as you successfully complete a 12-month non-reporting probation. You will have all standard conditions of probation. The officer will go over those. You are ordered to contact probation as soon as this hearing is over. Are you able to write their phone number?
Yes.
Tell me when you're ready, please.
Ready.
In addition to standard conditions of probation, you are to remain compliant with all existing mental health treatment and recommendations. If probation determines that they want a more exact or updated mental health evaluation, I will give them authority to require that, and you must obtain it and pay for it. You'll also be responsible, although there's no fine and no restitution, you'll be responsible for $158 in court costs, $100 to the Domestic Violence Offender Fund that helps for the expenses of victims of domestic violence. You'll have to pay a $60 supervision fee. And then it looks like what kind of work do you do there?
Electrical.
Electrical
Residential electric.
Okay. Well, I'm going to order that you pay $250 of your attorney fees. I believe that comes to about $568. How long do you think you'll need to pay that? 90 days enough, do you think? Is
That'd be okay. Yes, ma'am. Yes, Your Honor.
I'll give you 90 days to pay that. Your probation officer can give you instructions on how to pay. Anything else we
Okay.
need to take up, Mr. Regier?
Your Honor, if the court is ordering the defendant to reporting probation, is the court also finding that counts 1 and 2 are dismissed pursuant to plea agreement?
The court is finding the defendant, it's ordering the defendant to report immediately to probation after this hearing. The court is dismissing counts 1 and 2 pursuant to plea agreement with prejudice, and that is on motion of the state.
Nothing further from the state, Your Honor.
All right, then Mr. King and the Roths are excused from these.
And Judge, I did want to let Skylar know the probation office is probably closed right now. They probably won't open up till 1:15, but make sure and call and keep calling them until you talk to a live person, okay?
Okay.
We're good. Thank you.
Thank you. You may go, sir.
Be safe, be well, sleep sweet, and much love.